welcome all of you, ladies and gentlemen, to Lexposium 2025, a cradle for future jurists. This prestigious event is being graced by legal luminaries, former chief justices, Supreme Court judges, eminent advocates, and thought leaders, all gathered with a common mission to shape the future of law in India and to empower the next generation of legal professionals. To open this landmark conclave, we now invite a visionary educator and the driving force behind the SRM group of institutions. Please welcome Dr. T.R. Parivender, Chancellor of the SRM Institute of Science and Technology, for the opening address.
Honorable Chief Guests, SRM is a well-known university in India, and it is successfully managing and running courses like medical, engineering, dental, arts and science, so on. Though it's a 40 years old university, regarding School of Law, 11 years old, the law school was started, and Maryland of US Supreme Court Chief Justice at the time, she graced and opened this law college. The academic concerned, SRM University is never second to anybody in the country. Therefore, I do not think just like law education is along with the other one. You are the really need of this country. The Constitution, you all know, there are 4 pillars for the Constitution. One is executive, legislative, judiciary, and press and media. These are all called as 4 pillars of this country. Remember, SRM concerned, whether it is engineering, non-engineering, we give our best infrastructure. So this university concerned, we never compromise infrastructure, quality and discipline. So I wish you all the best.
Thank you very much. We now invite Dr. P. Satyanarayanan, Pro-chancellor Academics of SRM IST, to deliver a special address to set the tone for today's powerful conversations.
It is with great pride and a deep sense of gratitude that I welcome you all to Lexposium, a celebration of legal thought and, more importantly, a reaffirmation of our commitment to justice, truth, and transformation. A law school must be more than an academic institution. It must be a crucible for conscience, a space where the law is not only learned but lived. It must equip students not only with the language of law but with the moral clarity to question power, the humility to listen, and the courage to speak for those who cannot. At SRM, we do not see legal education as a lifeless study of rules and procedures. We see it as participation in a larger unfolding where each student became a change enabler, not in isolation, but within the greater web of society, history, and the evolving systems. As educators of future legal professionals, we carry the responsibility to nurture individuals who will uphold this remarkable pedigree of integrity, trust, and constitutional duty. In law, we often aim for justice, but justice is shaped by process, precedent, and perspective. Truth, on the other hand, is often elusive, complex, and uncomfortable. But without truth, justice cannot stand. We believe that the legal education must teach the students not just how to argue, but how to seek, not just how to win, but how to understand. And so we are not in pursuit of victory or certainty, we are always in pursuit of truth. To the students who are here, you are not just learning the law, you are learning how to be a part of something greater than yourself. May you rise on not just to interpret the law, but to embody its spirit. To our faculty members here, may we continue to educate not just sharp minds, but wise souls. Let us now open the floor to those whose judgments shape our laws and whose lives illuminate them. Thank you very much.
Please join me in welcoming Honorable Chief Justice of India, retired N.V. Ramana, to deliver keynote address of the day.
Institutes such as SRM have brought a world-class education closer to home. They have ensured that talented young people do not have to migrate far. By imparting value-based education, discipline, they have contributed to regional growth, leadership, and strengthened the economies. Most of you gathered here are law students. I congratulate all of you for choosing law. I wish that all of you join the practice. Although it is one of the most challenging professions, yet it is very exciting. What is the message I want to tell to the young students is, legal education does not end in classrooms. There is a great disconnect with the grassroots realities of our society. Books will teach you the letter of the law, but society will teach you its spirit. As young lawyers, you must expose yourself to varying experiences of legal practice in trial courts, tribunals, different institutions and forums. We have a great constitution. We must work towards the proper implementation and realize its goals and aspirations. It should be our constant endeavor to bridge the gap between the Constitution and the people. As future national builders, carry forward the spirit of the Constitution in every step in your career. Be fearless and upright. I will end my speech with Rabindranath Tagore, where the mind is without fear and the head is held high, where knowledge is free into the heaven of freedom. My Father, let my country awake. Thank you very much for giving this opportunity. Thank you.
If you could reimagine the legal education system in India to prepare future lawyers who would then perhaps some of them go on to become judges, what would be your top 3 priorities?
Priority number 1, see, unlike medical schools where there is an internship, so internship would mean that you have to actually serve the society for 1 year. I don't know why they haven't introduced that kind of internship when it comes to law as a course. Is it only that medical students alone are supposed to serve the society?
Right.
Why not law students? So therefore, as a legal education, perhaps I think that part is something which must get added. Right. Then the second part, I would submit, and I agree with Justice Rastogi when he said that this 3-year kind of situation to join judiciary may not be necessary. You can reduce it to 1 year, and those who have done public defender's office 1 year, they should be straight away considered to be taken for the judiciary kind of, postings. So therefore, that way you will create an awareness amongst the students that if I do this internship, there's an horizon which is waiting for me in the form of, say, judicial service as such. So therefore, there are a number of ideas which can be implemented like this, which will make your legal education very, very substantive and very sharp and focused one.
Thank you so much, Your Honor. It was a pleasure speaking to you, and thank you for taking the time out, coming all the way to Chennai to be with us. Thank you once
Thank
again.
you so much. I enjoyed this. Thank you.
I would now like to invite on stage Hon'ble Justice Dr. Anita Sumanth of the Madras High Court for a keynote address on justice beyond the courtroom, exploring themes of accessibility, affordability, and legal awareness. Ma'am.
Vanakkam and Namaskaram. Let's picture a courtroom. Not just any courtroom, but the ideal one, where the scales of justice are perfectly poised and balanced. On the one hand, you have the Constitution, etched with the promises of liberty, fraternity, equality. And on the other hand, we have the citizen. An ordinary citizen like you or me, but extraordinary in his or her uniqueness, seeking dignity and fairness. The truth is that the balance that I spoke about just now is a very fragile balance, one which requires constant vigilance, courage, and innovation to sustain itself. The first point that I want to make is this. Though we speak of justice beyond the courts, this institution and all its stakeholders still plays a very key role in taking justice beyond the courtroom and in ensuring accessibility, accountability, and affordability. 39A of the Constitution states that there should be equal justice for all. That's the first point. The second point is alternate dispute resolution mechanisms, justice even before you reach the courtrooms. The third is the use of technology. The silver lining of the COVID pandemic, if at all, one could say that it had a silver lining, was that it propelled us overnight to seek modern methods of justice resolution. It fast-tracked the use of technology in courts. Overnight, courts had to frame video conferencing rules. We had to get the infrastructure for the cameras, the screens. We had to train our judges on how do you conduct courts online, and all this to enable virtual hearings. Today, we also have online dispute resolution platforms that allow parties to resolve conflicts without having to step into a courtroom. There are also offenses like traffic offenses where you've got virtual courts, where you don't have to go to the court at all. You receive a summons and you have a link which takes you to a court, a virtual court, where you're able to settle the dispute without having to access the adversarial system of litigation. And now coming to the last, the strengthening of institutions that are the guardians of democracy. And this starts with you and me. And when I say you and me, this is irrespective of whether one is a judge, when one is a lawyer, when one is a media person, or whether you are a student. All that matters is that we are citizens, equally interested, equally committed, equally passionate about taking justice to the doorstep of the man who doesn't have that access today. That's all it takes. I will end by saying that you would all be familiar with the phrase qui vive. It's a French term which means who goes there or who lives. And in the context of law, it was used first in V.G. Rao's case by Justice Patanjali Shastri, who says that he calls the Supreme Court a sentinel of qui vive, which essentially means that the Supreme Court has to be on high alert at all time to ensure that justice is not denied to any person at all. We should all be on qui vive mode all the time to ensure that if we find that justice is being denied at any juncture to any person, we raise a voice, we raise a call, and ensure that every individual feels seen, heard, and valued. Thank you very much.
I just hope it's the real Cyril Shroff who's joining us and it's not an impersonator who's coming online. But let me begin with a broad question, Mr. Shroff. You've set up the Cyril Shroff Center for AI Law and Regulation. What are the three key challenges that the Indian judicial system and legal framework faces from the pace of technological transformation?
I think one of the challenges, and which kind of emphasizes the need for protection against certain inherent flaws that technology has. For example, we know about the risk of hallucination in AI, and particularly the large language models. There is bias. There are safety issues. We've seen in the last few days some cases where people sort of developed almost like a relationship with a chatbot, and some young minds committed suicide. Who is responsible for this? This is a safety issue as well. And of course, the law will have to find a way of dealing with it. And the third big challenge that I see is capacity and capability. Capacity and capability in government and the policy environment. Capacity and capability in the judiciary and in the legal profession. And capacity in capability in the legal profession as well. And part of the motivation for setting up the center was to assist, make at least a small effort to assist in this capacity problem.
Thank you very much.
Joining us now, one of my favorite lawyers, Pinky Anand, former Additional Solicitor General. We have Pradeep Rai, Senior Advocate. And also in the Supreme Court of India, we have Nalin Kohli. We have Sudha P. She's the Dean, School of Law, SRM University. Thank you all of you for being part of this show. Pinky Anand, to you first. What are the main judicial reforms, ma'am, that you can think about that have taken place in the last 10 years, which have made justice accessible to all Indians?
So what are the judicial reforms and what is the stages that we have gone through? I can identify a few of them, and there are several, by the way, so I can go on forever. I don't want to do that. But to my mind, one of the most major constitutional amendments that we have done, which has really brought national integrity into focus, is Kashmir. I think Kashmir and bringing of Kashmir and abrogating Article 370 is the biggest step that we could have taken, and we did this all the way back in 2019. Something that nobody could do, we have done, and Kashmir is back in the fold. It's another matter, of course, you've Operation Sindoor somewhere on the outskirts of what is happening, but bringing back a part of India within India and completely so that the laws can be accessed by all the citizens there. And incidentally, aside from laws, even the economic integrity, even the progress in all ways has gone across because the laws and the constitution applies to Kashmir.
So Mr. Kohli, when the opposition says that the autonomy of institutions is being undermined, and specifically with regard to what happened with the bail application of certain protesters, or for that matter SIR, how do you look at that kind of criticism?
Essentially, rule of law has to also keep pace with the progress of society. And that's why, if you will see, there's the removal of antiquated laws, there's cleaning up of it, there's a new criminal code so that you can bring in speed. Time requires law to keep pace with those developments. How can the denial of bail be a weakening of an institution? So I would say we have young minds in this university, they are law students. Let them go ahead and hear what those who have sought bail said on public forums, in open forums. What? That we of a certain community must keep out the others, or the other community will come on our terms into our protest. We will, with numbers, break India's link with the Northeast in the chicken neck. In the chicken neck, so that is broken away. That is our area. This is not just an intent of secession. This is equally important, an enunciation that we will even do violence if required. Rule of law requires a peaceful society. Our constitution gives equal rights to each one of us. Now, yes, in a democracy, the counter viewpoint can have a point of view. Yeah. We welcome that. But that doesn't mean that the institutions have become weaker. That is the view of someone saying that we have no faith in the courts. So you can't have it both ways. I have faith in the court when it gives bail. I don't have faith in the court when it doesn't give bail. So I think that should answer it.
Pradeep Rai, is Viksit Bharat in some ways compatible with the opaque system of judges appointing themselves? Is India the only country to do something like that? Why is the judiciary so hesitant in sort of accepting greater accountability when it comes to its own appointments?
You would suggest me any better idea in which, other than the judges appoint judges, which exist in any other country, especially in Indian circumstances. The problem is that if you give it to the politicians, still political clout works, still political interference is available somewhere. Many judges, they belong to different political parties. In the US, we have seen that many political persons were appointed as judges, but because there is no retirement age, so there is no undue influence over them. And mostly, I don't say that each and every appointment is correct. I will say that many appointments, you may raise an eyebrow, you may say something against that, but 90% or 80% appointments, I will say that that is right.
Dr. Sudha, when we talk about simplification of India's legal procedures to make them truly citizen-friendly, there's one thing that comes up very often is the pendency of cases. How are we looking at making justice affordable and also friendly? What kind of radical reforms do you suggest?
First of all, the first important reform we have to introduce in legal education is that establishment of clinics. Being an IP teacher, simply teaching what is the subject matter, instead of that, we have to give real-time problems and we have to train the students for solving these problems. And the second important aspect is that, like recently we have passed this mediation bill, like Pradeep Roy sir has rightly stated, we have to train the students not to pose the questions, but how to solve those questions. And the third important aspect we have to introduce in the current day legal system is experiential learning.
Clearly, equality and fairness need to be the cornerstones of Viksit Bharat, and that should remain not just our commitment but also our responsibility. Thank you so much.